Stanley Zamor. Stanley Zamor, Florida Supreme Court certified family, county, circuit mediator, primary trainer, qualified arbitrator, and just want to help people, corporations, entities deal with conflict different. We're going to always have conflict. Conflict is inevitable, but I do believe your resolve is as well. So they're going to have a method of resolve. They're going to have a response. You're going to have a way to negotiate past the ebbs and flows of a divorce, of different trial work that Steve, that you're going to talk about that you do. And it's important that people at least hear some dialogue sometimes from people who are professionals in this area in a passionate way, not despondent, not stoic, not the humdrum, but how do we get things done? So there's definitely one particular sanction against a mediator that I'm frameworking this conversation about. But Steve, I know who you are, but for those who might be listening to this later on, a brief introduction of who you are. Go for it. Go goes on you.
Well, Stanley, first and foremost, it's just a privilege to be able to chat with you and your viewers for the next 15 or so minutes. Stanley is just the world-renowned mediator, trainer, and just an all-around good guy. So it's a pleasure to be with you, Stanley. And as far as I'm concerned, I'm a board-certified civil trial lawyer for the last almost 40 years. So I've been in the trenches for many years dealing with litigation and stress and so forth, and it's been wonderful. Been a certified mediator for the last 10 or so years, and for the last 2 years, I've been pretty much doing it full time. Very much enjoying helping parties resolve their matters so that they don't have to go through the undue stress of being in front of a judge or being in front of a jury or having to expend legal fees. And it's been quite rewarding, helping both lawyers and claimants put these matters behind them. It feels good, Stanley. So yeah, I've been very much enjoying it.
And like I said before we started recording this or taping it, or maybe it captured it before, you have been, since meeting you, which was how many years ago? I don't even know now, 6-7 years ago, maybe, at FLN, right?
Sure.
You struck me as a person that got it, and I hate to sound a certain way, but I've been a mediator for over 20 years, 24 years. Actually, May of this year made 24 years. So I've been doing mediation since 2000, but during that time, I was working in large law firms, small boutique firms, handling a variety of areas, intellectual property. I don't want to go through that, but a lot of different areas of law. And I end up finding that through my PhD, all but dissertation, studies in conflict resolution, mediation, arbitration, and the other various areas of what makes up alternative dispute resolution processes, and there are many of them, advocates like yourself, lawyers, and again, you're not just a regular lawyer, you're a board certified trial lawyer. That's not just go to law school, passing the bar. You took extra steps, extra things, so it should be recognized that you're not the normal. There's only, I know for a fact, the percentage of board certified trial lawyers is small. So you know what you're doing on a very high level, and I definitely appreciate calling you a colleague and a friend. So when I hear someone like you who's like this really tries to do good work on the trial level, but they also get it when it comes to conflict resolution, it kind of inspires me that there are people out there that can do this thing called mediation, helping parties negotiate and do it the right way. Because there are tons of mediators. I'm just going to be blunt. Tons of them in the family area, in the commercial circuit civil county area, and a lot of them, after what I've done and researched and been involved in, they do a lot of borderline unethical things to get things done the way they feel it should be done, as opposed to really, as we discussed, engaging the parties and their advocates or their representative in a way that creates a process where people can get what they need, not just what they want. Does that make sense?
Sure, absolutely. You always make sense, Stanley.
Don't do that. Don't do that. Don't do that. But that's why this why I sent you that one consent agreement, which is a part of the sanctions. People, one, don't realize mediators can be sanctioned, they can be grieved, they can be complained about. Everyone thinks they have to run to the Florida bar. It's not the Florida bar, it's the Florida Supreme Court dispute resolution section. And there are things that people have engaged in or experienced in mediation that, or in negotiations with a mediator, being the person that helps facilitate the conversation, that they didn't know could not happen. And I'm talking about this past weekend, I trained a few people. Some were judges, some were former judges, some were litigators that have board trial experience, and some were just professionals that negotiate often because of what they do for a living. But in all, they all had a lot of experience on being on one side of the table, being a sword, as I like to say, being a sword or being a shield when it comes to conflict. Okay, and we as neutrals are that in what I would like to see, a bridge or brick to try to find some other way of resolution. So just jumping into this agreement, this consensual agreement that I sent you, which is a 2021 case. What are your thoughts on it? And I'm not going to read it because it's just too long. But basically, just to preface it, someone, I don't even know who, but someone complained and grieved about a mediator who gave his professional opinion during the negotiations. And as from what you know, and I'm sure you can tell, there are tons of mediators who do that, right? So what are your thoughts on that?
Well, it's funny you say that. So 30 years ago, I had a personal experience as a young puppy lawyer where the mediator was this gray-haired, seasoned former judge on the bench who looked me in the eye and my client and basically said, your case is horrible and you're not going to win. And you should take the money that's being offered.
So
I'm pleased to say...
You're saying a mediator that you were advocating for someone, and before trial, before anything else, you had to go to mediation, because now, of course, it's mandatory. You will be going to mediation at some point in time in your case, right?
Right.
And you're saying that you went to that mandatory mediation, and while you were there, this person who was a former judge told you that your case was bad and you should take what's being offered now, right? Okay. And
well, not only that, but he told my client that also. And what I was going to say is I was pleased to say we ended up trying the case and there was a significant verdict in favor of my client. So I can tell you that it had a happy ending, but that's not really the point of the story. The point of the story is mediators have to maintain a neutrality. And, usually I'm wearing a navy blazer when I do my mediations, Stanley. And I always say, in case you can't tell, this is not a black robe, this is a navy blazer. So I can't make any rulings today. I can't hold anybody into contempt. And most importantly, I can't force you to do what you don't want to do. So it's not a job of a mediator to render a decision. It would be foolish anyway. We live in a world, with social media, which didn't exist back in my early days, Stanley. And we can all see that really nobody can agree on anything.
No.
Nothing is black and white. Nothing is right and wrong. And everything is spun. They call Facebook Fakebook for a reason. And honestly, any lawyer or mediator or judge to tell someone that they know exactly what's going to happen with their case is foolish and inexperienced, because anything really can happen. And, so it's just improper. It's wrong. The duty of a mediator, especially one that's been experienced in the type of cases that they're handling, is not to, because let's put it this way. If we knew what was going to happen, there'd be no need for a mediation. There'd be no need for trials, because everybody would know what the result's going to be. So that, so that first and foremost. Well, I don't know. Again, that's above my pay grade, Stanley. I'm a little older. I'm going to have to learn about AI. I guess that might put us out of business one day.
Never.
I can say that I am not an artificial intelligence person, but we're getting off track. The point is, I think a good mediator can pose the type of questions that gets that same result? In other words, what do you think your likely result could be? What if you try this case 10 times? How many times will you win? How many times will you lose? If it's dealing with money, what do you think the value is going to be? What do you think juries would come back with? What do you think the range might be? If you think there's an issue of liability or causation, you can ask that question. How many times, will they find your client at fault? Will they find your client partially at fault? If, and if they do, how does that affect the sum of money that they get?
No, hold on. Let me pause you, because what you're doing right now is talking I mean, it may not seem this way, but it is. When we're talking about being a neutral, impartial facilitator of a process, ergo a mediator, what you're asking is advance in the skill sets of how you ask questions, how and it's to elicit conversation, is to elicit the party's own wants, needs, and expectations, and to encourage thoughts, encourage dialogue. I'm using words choices on purpose a certain way. So I want to pause because you're doing and saying things so nuanced. I don't want it to be missed. First of all, what you said was in your introduction, which I think, I don't want to blow smoke, but it is an advanced feature. It is an advanced thing, and it is masterful how you said that. And everyone has their own style. I understand that. So everyone, I'm not saying all neutrals, all mediators should do the same thing, but take note at what you say, did, and how you've changed their perspective by saying, what I'm wearing right now, you may not see it, but it's blue, navy blue. It's a suit, it's a jacket, as opposed to robes. By just giving that imagery, you are subconsciously affecting their perspective, because although they may have had a conversation with the paralegal, with the associate, with the receptionist, with the junior associate, with the main name partner that might be at trial, although all those people in a law firm may have had a conversation with Mr. Joe and Mrs. Public, or whatever it may be, as to we're going to a mediation, he will not make a decision. In the novice person's mind, they see you, they see your room, they see where you are, they see that beautiful Farbman mediation room. Oh, he's fancy. And with the judicial scales there as your image, they're going to think subconsciously he could help us by rendering a decision, giving us his opinion. So by you making reference to that, you hopefully start to change perspective. But again, what you have back there is called a meta message. The meta message may be different, but the imagery you're presenting as to recognizing this is not a black robe, so don't expect a ruling or a judgment of some sort, is important. And that's how we start to gain, hopefully, a trust they have in the process, and trust they have in us as neutrals, that even if we don't give them our opinion, that's a benefit. It's a good thing that we don't give them our opinion. And even if you're experienced in trial level, like you said, anything can happen. We're in Florida. we're dealing with people that have a driver's license and that could therefore be part of a jury, and it could be go left, go right for anyone, right? So let's not. So I just like your intro and how you start setting up their ideas, because I guarantee you, in that sanction that I just mentioned to you, I highly doubt that person did that consistently and maintained that neutrality throughout the process, which he couldn't have. Otherwise, he would have been grieved for giving his opinion, right? 2, what you just paused and said, how you help through the process by engaging in the type of questions you asked. Also fantastic. And also a technique that most neutrals should learn is the type of question. It should not feel like an interrogation. It should not feel like you're in deposition part 2.0. It should feel like a conversation that you pull from them what their wants and needs are. All right, I'm sorry to stop you, but I just wanted to make sure those nuances were at least acknowledged. Would I make you scared? But you did real.
No,
that's why I said it's.
I think you've. I mean, the point. I think the point, Stanley, is, you as a neutral person or a mediator, you mentioned AI and we're not just, I always hate the term that some, people have found mediators as number takers. They walk into one room, they get a number. They go into another room, they get a number. You can't, to me, you don't need a mediator for that. You can do that there used to be a computerized system where some of the insurance companies you would go online and you'd go, I'm asking for this number. They would respond on a computer. This is that number. You'd go back and forth. That's not mediation. You shouldn't discount the experience and the knowledge that your mediator has. And for better or for worse, after 40 years, I have a lot of, I've been through a lot, and I want to help share those experiences with people so that they don't make the same mistakes that perhaps I made, or that they can take advantage of certain situations that might come their way. So that, it's not just go ahead.
How can we address, stop, or recognize those neutrals or people charged to help people? How can we help address those who may not do what you're doing, but do say, hey, listen, I see you going down the wrong, and maybe in their mind, I see you going down the wrong path. I am going to interject. I am going to tell you how poor your case is. I am going to tell you that the way you're litigating this to their lawyers is going to lead you to XYZ. I have been doing it for 40 years. I am experienced. How do you think that could be addressed and recognized by those advocates that may not be wanting to get that opinion, like what you said? When you were younger, you didn't want to hear that from that judge or from that mediator who was also a judge, former judge who now mediates, right? You didn't want to hear that. So how can they address that? What do you think?
I think, like I said earlier, you have to discuss what the main issues are in the case. And if I think you first ask what they think the main issues are. And if you, from your experience, are aware of perhaps other issues, you have to pose that question, like, what do you think about this? Or what do you think about that? Or do you think this will be a problem? Or will this help you? You have to let people, because keep in mind, most, whether you're a plaintiff or a defendant or a petitioner or respondent, sometimes you're just hearing one side from your lawyer. Mediation sometimes is the first time they're going to hear what the opposition has to say. And it's not all going to be what their lawyers told them. It's going to be other arguments that they may not have considered. So during the mediation process, you have to discuss those other arguments and at least let them make a decision whether they think that's something that they should be concerned about, or maybe they shouldn't be concerned about, but at least discuss. Because I always say mediation, while not technically free, is kind of a free ride to see what their trial's going to be, what kind of testimony is going to come out, and what either one judge or 6 strangers on a jury are going to decide. And today, during your mediation, is a great day where you have control over what's going to really control over your fate. Because once you go into a trial, you have a certain amount of control because you have a great lawyer, hopefully litigating in your best interest, but there's also going to be a very good lawyer on the other side, and there's too much uncertainty.
It's funny.
So if you...
it's funny. I'm sorry to interrupt you. What's interesting, what you just said, and I'm writing this down. Everyone is a 10. Here's what I mean by that. I do a lot of conversation, dialogue when it comes to couples, relationships, and stuff like that, dating as well. I get involved because of the aspects of children, the family law, mediation, post-divorce, parenting plan stuff, a lot of things, whatever. A lot of different avenues with a lot of different groups of people. My network of communication is pretty vast. So I find myself every week in all these little pockets of communication with a variety of network of people, professional and non-professional, that deal with individuals, professional and others, right? Here's what I'm coming from. So I'm coming from what you said. You said they picked a great lawyer. It's like when I hear the conversation from a group of people, not going to say the gender, I'm a 10. So you're all 10s? Someone got to be a 5. Someone got to be a 6. You're all 10s. Yeah, and that's like that. I'm that blunt with it sometimes. So everyone has a great lawyer. Everyone has a great lawyer. We're all winning. We're all gonna win. No, we're all not gonna win. We're all not 10s. They're not, or they don't all have great lawyers. They are not all in great circumstances or situations, especially when you talk about, as you said, 6 individuals that may not be having their best day that day. So therefore, they're on their own agenda, right? Or even the judge, the trier of fact, or an arbiter, that may not be having their best day. And I'm sorry, it does. We're human beings. It does impact. It does influence. So how best we can take control and remain in control of the outcome, and that's the difference. Parties, divorcing couples, or maybe even cohabitating co-parents, whatever, entities, municipalities, law enforcement, whatever. If you're engaging in this process called negotiations through mediation, you're in control of the outcome. But the neutral, you and I and others, are in control of the process. So what I encourage people and lawyers to do is when they select a mediator, select one that has maybe definitely have someone that has subject matter awareness. I think subject matter expertise biases them too much, but that's just me and my philosophy of thought. But do they have an expertise in conflict resolution, an expertise in creating dialogue, an expertise in going beyond impasse, an expertise in what you said, getting them not only to understand and see things in their case, but can we have an appreciation and a value for another perspective? And if you can help them with that, that is how you select and get good neutrals, is with those that have the ability, not to say, well, I got 5 more cases with this lawyer. I got 5 more cases with this particular firm, or I know this guy, I know this girl. Let me get them what they want with their clients. And I'm sorry, that's what's being done, which is why this opinion exists. And there's another one out there. I'm not going to go too deeply into that. I'm gonna say it for later on, but there's another consensual agreement, MQDRB, which stands for Mediation Qualification Dispute Discipline Board, right? Sorry, Review Board. MQDRB.
I say that 5 times real fast now, Stanley.
I can't do that because I stutter. 2023-007, where it specifically said the Rules Violation Committee, a subsection of the MQDRB from the Florida Supreme Court, they sanctioned the lawyer for being, as they say right here, simultaneously acting. You know what? I might just pull it up just to make sure that no one thinks I'm making it up. Here it is right here. Simultaneously acting as the plaintiff's attorney in a case in ongoing litigation against the defendant insurance carrier, and acting as the mediator in an unrelated case in which the defendant insurance carrier was also a defendant. So, as you know, I train a bunch of lawyers, a bunch of judges, a bunch of professionals that have a connection with certain things. I'm like, be careful, because if you're gonna do this thing called mediation, you got someone right here. It has happened before, but I will point it out. Be careful, because if you're going to continue to do cases in a particular area, but yet later on, you're also the mediator, you might have a problem, because those people that continue to do that at that level are biasing themselves. They are. And if they say that they're not, doesn't matter, because although I think they can do a good job if they're good litigators and mediators, and you may think so too, Joe Public may not know that. The non-attorney who might be there because of whatever interest they have, they're there as a board of directors of a HOA or condo case, whatever, they may not know that. So they're being impacted and influenced in this process. And as our rules are written, we as neutrals have to be aware of that, more so than the people who hire us. That means you may not be able to take certain cases. There's tons of cases I can't take because of this. But guess what? it allows for a good process, and it's non-waivable. How about that?
Well,
Tough?
I think that a good mediator, I don't know, I don't agree 100% with that. So, I mean, I mediate for people who I've had relationships with.
No,
I
one's saying you
mediate
can't
for
do it. You have to
people
be
I'm meeting for the
careful.
first time. I'm mediating for carriers who I've litigated against when I'm, as a practicing attorney. You're wearing I believe you're wearing two different hats, and it's, you're not discussing if if you have a case against the carrier and a mediation against the carrier. If you're being ethical, one has absolutely, I think, has nothing to do with the other. It may be contrary to the opinion that you're discussing, but neutral. You're not supposed to be doing anything to influence favor to yourself or any sort of future benefit. I think the success you have, like I said earlier, or maybe I didn't, is to get a case resolved. When I've heard it over and over again, which I disagree with from mediators, is when a mediator starts his mediation and he says, the best mediation is when everybody leaves unhappy, but the case is resolved. I say the complete opposite. To me,
they leave unhappy.
Yeah. I say the opposite. I say, to me, the best mediation is when both parties resolve the case, and they're both happy that they resolve the case, and they're both happy because they felt that they both did the right thing and got a fair result for both sides. And honestly, I have mediated cases where after it's both said and done, the plaintiff attorney calls me and says, oh my gosh, I can't believe you were able to successfully get that done. My client is so happy. Thank you so much. And 10 minutes later, the defense attorney calls me up and says, oh my God, I can't believe you were able to get this done. My client is so happy with what they had to pay. Thank you so much. I mean, to me, that's the golden goose. That's the greatest achievement. So,
well,
so they're both going to be happy, and I'm not like favoring one side over the other.
How about a case where they both call you, and I've had, I'm thousands of mediations in, thousands. How about you get a call or you get an email, or you get some kind of communication from both sides, unsolicited, within a day or two apart, where they thanked you for the process, they thanked you for the mediation, and it did not end in a settlement. I get those.
Well, that's great. Well, what I do in those cases,
you know why?
Stanley,
do you know why that happened?
And you brought them closer. You helped shed light on certain issues. And what I was going to say is what I'm sure you do and I do. On those cases where there's either an impasse or an adjournment, I say, look, here's my cell phone number. I'm gonna email you guys in a couple weeks and see if I can help out.
Amen.
And no charge. And I get personal, personal gratification by getting a case done. And in a couple of weeks, it still doesn't go. As you know, Stanley, we're on the email list for these cases right up to the point where the judge is sending, or the JA is sending out emails going, hey guys, calendar calls next week, you number 3 for Monday. And I'm shooting out emails going, guys, I see your case is going to trial next week. Come on, give me a shot. Let me know if I can help you out. You want to shoot me an email. You want me to be the intermediary here. I'm more than happy to do so. Sometimes it works, sometimes it doesn't. Stanley, sometimes cases need to go to trial for whatever reason. I obviously, as mediators, we would like to think we can achieve resolution with all of them. And they probably, in a perfect world, all could get resolved before. But sometimes they go.
I want to alter what you said, and hopefully your mindset.
I'm glad I'm making you think today, Stanley.
They all reach a resolution. The type of resolution is what they need to worry about, is what they need to want. Sure. The type, because I know plenty of cases, and that's why I teach this, that the mindset shift, as well as in mediation, I deal with. I tell them, you're gonna get a resolution. And I pause, and I wait for the rolling of the eyes, or what do you mean? You're You're going to guarantee a written agreement? No, I didn't say that. You will have a resolution that's right for you today. It might be an impasse. It might be an adjournment. Might be temporary. It might be a full settlement, partial settlement. There's a number of ways it can go. But I guarantee you, by the end of our time together, however long it is, it'll be the best option that they could achieve. Sometimes there's not enough money that day. Phone calls have to be made. Sometimes there's not authority. I don't know. Oh, they should come with full authority. We know how it is, unfortunately. Sometimes they do. And guess what? The ethical process allows for that still. Even if the court order might say everyone must appear with full authority which to resolve the case without further consultation, we know that the rules allow the flexibility that should they not have that authority, we can pause to allow for them to get that authority. It allows for that. And that's the difference. I've seen some mediators blow up an opportunity because they were like, this and you don't have, and I checked and I went online, and online I saw who was supposed to be here. It ain't you. So therefore, I'm going to put to the court that you didn't appear. You wasted our time. Bye-bye. I'm like, whoa. When I've seen it, and I've seen it, and I've heard it, and I've heard it, I've had litigators contact me, not giving me details as to who it was or to case specifics, but what can I do as a litigator? I give them different techniques that I won't mention right now, but different things that they can do. But definitely one of them is, well, you have to be very careful of who you selected. But two, in that case, the mediator didn't have to be all that and do all that. They didn't have to do that, but they did it because of what? Maybe other motivations. And I don't want to disparage other people, but you know what? When we have this many issues coming up and we have blatant sanctions that are just hitting people hard, the two of the ones I just read to you, I didn't think that would be possible or as relevant as they are in 2024. Because I'm like, mediation has been codified, and has been used as a process by the court system. It is not attached to the court system. It's its own separate thing that people think is an arm. We're not an arm of the court. We handle things sometimes to assist the court, but we are our own separate thing. So that was since 1988. 1989 when it became codified, right? So I would think since it's been being done for so long, that's a pretty elementary basic thing not to do, but people are still doing it. So think about that. It's kind of like, can you imagine if you heard, an attorney used their trust account to pay for a vacation, right? Does it happen? I have heard.
That'd be ridiculous. They'd be idiots. I'm sorry.
That's my point. You would think they were. I sit on a couple of. I am on the Florida bar. I'm on some grievance panels, but nonetheless, that's not the case. The whole thing is that's ludicrous. That's like lawyer business 101, right? What not to do. But you have that small segment doing that still. You have a bunch of complaints throughout the year. A bar complains about lawyers doing things that you think would be relevant. How do you not know not to do that? It happens. Why can't that happen with mediation? So that's my point. These things have happened so much that last week I did a few mediations where the litigators were like, wow, I didn't know you could do it this way and that way. Or I was doing things. They're like, why aren't you giving me your opinion on this, Stanley? I'm like, well, because I'm ethically bound not to. They're like, you are? And I pulled up the rule for that lawyer doing a private meeting called a caucus session, right? I pulled them to the side and said, yeah, here it is. Rule 10.370C. And they're like, I did not know. I'm like, well, why would you know? Because most of the mediators that you may use are just trying to get her done. And their value is forcing a settlement when that may not be what the parties need for that day. There can be satisfaction in the process of mediation that maybe does not lead to a settlement agreement because that day is just not possible for whatever reason. It's not a bad thing. It's not an unsuccessful case. I've had also in family. I know you don't do family, but in family, there's a lot of times where people come, cases are a year old, 2 years old, but that day at mediation, we realize there's a lot of interest that hasn't been, maybe financial interest or things that are up in the air, business-wise or whatever it may be. where more information is necessary and needed. So we have to pause the breaks, trials in a week or 2 weeks. Let's pause and come back. I'll come back. And like you, I'm that type too. I'll come back for free for an hour, at least an hour. Not the whole thing, but at least an hour to say, okay, we were missing X, Y, Z. Let's get back in there. But more importantly, Mr. and Mrs. blah, blah, blah. What are your goals? What do you want to see happen? After your lawyers are gone, after the judge is gone, after the parent coordinator is gone, after the mediator is gone, it's going to be you two co-parents, like a business, raising other businesses, your children. What do you want to see? What are your goals for them? What are your goals for how they perceive marriage, how they do discourse, how they have future marriages or future relationships? It's all going to depend on how you end this today. Oh, sorry, how you end your case eventually. And they're like, holy smokes, didn't think of it. And they're, unfortunately, divorce, parenting cost way more than that beautiful wedding, than those nuptials. All right, I know time is of the essence. Is there anything else you want to reference or mention in regards to this whole idea of this opinions being offered by neutrals?
The only thing I can say is, look, I'm a 63-year-old white guy who has practiced law for 40 years in South Florida, okay?
Like peach colored.
Okay, all right. And so even if I had an opinion, my opinion will not be what 6 jurors, and highly doubtful, it's not guaranteed to be what 6 jurors who, like you said, from age 18 to 70, from different parts of the country, from different parts of the world, who are sitting as a juror, who are Gen Xers, baby boomers, millennials, you name it.
Gen Zers.
Their opinions are going to be far different than mine anyway. And that's something that, people that are going to a jury trial, have to know. So that's why I said earlier, there's no guarantees. However, in the mediation process, you do have control to get the case done. It takes compromise on both sides. I always say the 3 C's, Stanley. You've got control today. It's going to take compromise on both sides. And if you both can agree and come to a resolution, you've got closure. The case is done. You stop paying your lawyers, you get some money in your pocket, or you know exactly what you're going to have to pay out, and it's over, and the parties that day had control. Like I said, if it goes to a jury or if it goes to a judge, someone else will be making that determination. And that's okay. Sometimes it has to happen that way. But that's why I love mediation, because if you've got the right lawyers that know what they're doing, if you've got parties and you can talk to the parties and get them to be, to get rid of the vindictiveness or hatred or upset that they might feel, step aside, look at this in a neutral fashion as if they were not the people involved. More times than not, you can get that case done, and it can be lifting a weight off of them, and they can move on with other things in their life that can give them joy instead of aggravation.
You know what? I'm glad, it's funny, it's not even practice, but your 3 C's mirrors a lot of what I have as my 3 C's, if not the exact ones, as also, and before I close, my 3 H's. Okay, so I like that. My 3 C's very much will mirror yours. Control of the process, control of the outcome. They control the outcome. Compromise, you're gonna have to compromise. You cannot get 100% of what you want. There has to be a give and take. And maybe today you give 60%, 70%. They take 30, but the next thing they take 30. They take 70. It's gonna be a compromise. You cannot be 100% even at all times. So be comfortable with understanding there's a power in compromising. Okay, so it's not a bad thing. It can be a beneficial thing because you're both agreeing. I'm going to respect your view. I don't agree with it. I'm going to respect it enough to compromise. So I know in the long run, we're both going to have an opportunity to have a certain level of what we want as opposed to what we need, right? So compromising is important. And again, the most important thing that I know who's been in different areas of litigation can see more than the parties that are in it when they're emotionally entrenched. You could get closure and end that part of the dispute. There's gonna be more fights to fight, baby. You're gonna have more things, but let's end this one as best as we can to set ourselves up for a better tomorrow and other things coming up. So closure. So I do the same thing when it comes to control, compromise, and closure. I'm gonna throw in there my 3 H's when it comes to finding good neutrals or people who could help them with their case. Okay, they're there to number one, to help. Okay? Are they there to help? What are they helping with and how? Are they hearing? Good neutrals have an extraordinary ability to listen greater than others. So can they be here? And also, are they here? HERE, present, mindful. What is the wants and needs for today's process? For today, or are they already thinking about their next cases? What can you get? It will be that help here and here. So let me end with that for right now. Steve, good times, man. I wish we had some burgers or something to have some lunch. It is like lunchtime, right?
Oh, we're gonna catch up. We're gonna have a lunch, and it's not gonna be by Zoom.
All right. So in ending, thank you, Steve, for your expertise. Thank you for your conversation. Thank you for giving your perspective on how you see things. I hope those that are listening can learn from that. If not, they know how to contact, or they will.